own loss. It's a big loss to him.
Sorry, sir.
Whoever
So
does
nice of you,
these
sir. So nice of you. Thank you.
Dhanendra
Actually,
ji
sir,
has also
today I'm
joined.
at Mumbai airport, sitting in the lawn. So because of noise over here, so there might be some issues. But I hope Vivek ji, my voice.
Yes, we can hear you.
Thank you.
Very
Thank
clear.
you.
Very clearly. Yes.
Hello, with the kind permission of VP sir, if he permits, we can start the proceedings.
Please, sir, please. I hope all the panelists have joined.
Yes, Senior VP, we have been joined by Dr. Sanjay Pandey, who's our keynote speaker for the day. He's the advisor, law and head advocacy division of the Competition Commission of India. Thank you, sir, for joining us this evening. It's a real privilege to have you with us today.
Welcome to you.
Thank you.
We are also joined by Mr. Dhanendra Kumar. He needs no introduction. He's an ex-IAS, founder chairman of the Competition Advisory Services at LLP and former chairman CCI. Thank you, sir. It's always a delight to have you with us at the PhD platform as well as hear you. I'd like to thank our other speakers who joined us, Mr. Vivek Agarwal, partner competition law, DMD advocates, Mr. Sharma, head competition law and policy practice, Vash Associates, advocates, Ms. Aditi Gopalakrishnan, partner, AZB and partners. Thank you very much all for joining us. And I can see the screen of Mr. Aseem Chawla, our co-chair for the Corporate Affairs Committee. It'll be nice to also have you on the screen. Thank you, Mr. Chawla. A very good evening to you. And I do not see our other co-chairs. Maybe they're trying to log in. But as the chair suggested, with the permission of the Senior Vice President, we will start the program today, which is a very intense topic on competition law, recent developments and impacts. Competition is not only there, to protect consumer welfare or protect consumers' rights, but it also fosters a lot of innovation. And it is also a way to stay at our best, the organization, the corporate sectors to stay at their best, ensuring that we always remain at the forefront of business and constantly push the limits of our capabilities to deliver the best to our customers. So with this little brief background, I would now like to request our Senior Vice President, Mr. Pradeep Multani, to kindly deliver his presidential address. Over to you, sir.
Thank you very much, Vivek ji. Good afternoon, everyone. On behalf of PhD CCI, I would like to welcome our keynote speaker, Dr. Sanjay Kumar Pandey, Advisor Law and Head, Advocacy Division, Competition Commission of India. I would like to welcome also other eminent experts for today's webinar, Mr. Dhanendra Kumar, IAS, Founder Chairman, Competition Advisory Services, LLP and former Chairman, CCI. Mr. Vivek Agarwal, Partner, Competition Law, DMD Advocates. Mr. Sharma, Head, Competition Law and Policy Practice, Vash Associates Advocates. Ms. Aditi Gopalakrishnan, Partner, AZB and Partners. I take this opportunity to welcome Corporate Affairs Committee Chair, Mr. Naveen N.D. Gupta, and co-chairs Mr. P.K. Rastagi, Mr. Aseem Chawla, and Mrs. Ranjana Agarwal. Mr. Saurabh Sanyal, Secretary General, PhD CCI, and today's session moderator, Mr. Vivek Sehgal, Assistant Secretary General of PhD Chambers. Ladies and gentlemen, PhD CCI has been working as a catalyst for the promotion of Indian industry, trade and entrepreneurship for the past 116 years. It is a forward-looking, proactive and dynamic pan-India apex organization. As a partner in progress with industry and government, PhD Chamber, with a special focus on MSMEs, works at the grassroots level with strong national and international linkages for propelling progress, harmony,
I'm
and
just
integrated
addressing one
development of
conference.
the Indian economy. PhD CCI is one of the
Let me
premier
finish
chambers
now.
of
I keep
in India to have been accredited with diamond grade by NABT QCI at national and international level. PhD CCI reaches out to more than 150,000 companies with total focus on the development of small and medium enterprises. The fact that competition is a complex notion and therefore not directly observable has resulted in the development of numerous methods to capture and measure the degree of competition in markets over the years. The ability to measure, track, and compare the competitive intensity of a market is an extremely valuable key metric to competition authorities and other policymakers for informed decision making. Along with possible diverse antitrust abuses, there is another challenge that is slowly emerging as a major concern, which is the convergence of competition policy and public interest. The core of antitrust intervention that competition benefits consumers is undisputed and perhaps axiomatic, but what is not accepted is that monopolistic market structures can also lead to enhancing public welfare. Emergent trends towards monopolistic markets suggest a rethink of competition policy and law and their convergence for public interest. Keeping in mind the need for a robust framework due to the growth of newer and disruptive models of business, the Competition Law Review Committee reviewed the Competition Act 2002 and released its report in July 2019. After incorporating certain reforms suggested by the Competition Law Review Committee, the draft Competition Amendment Bill 2020 was released in February 2020, which contains certain groundbreaking amendments which could completely revamp the competition regime in India. The bill proposes to statutorily recognize the green channel process to enable fast-paced regulatory approvals for vast majority of mergers and acquisition that may have no major concerns regarding appreciable adverse effects on competition. The aim is to move towards disclosure-based regime with strict consequences for not providing accurate or incomplete information. The power of Green Channel will also extend to approve resolutions arrived at in an insolvency resolution process under the Insolvency and Bankruptcy Code. Further, the bill also expands the scope of the Competition Act to include within its scope the digital markets. In order to achieve the set goal, the bill makes a number of changes in the existing system, such as inclusion of hub and spoke arrangement and buyer's cartel. Competition in the digital economy is increasingly a competition between ecosystems. The most successful digital companies in recent years have been building the business model around large ecosystems of complementary products and services around their core service. One more factor which needs a lot of attention is the role of competition in MSME sectors. MSMEs contribute around 35 to 40% of the GDP of India and are key to employment generation, sustainable development, and poverty reduction. On one hand, small size of the MSMEs makes them vulnerable to anti-competitive acts of bigger enterprises, including abuse of dominant position, and on the other hand, cooperation agreements among MSMEs assist them to compete with large enterprises. It should be emphasized for the avoidance of doubt that competition law does not set out to protect or promote MSMEs at the disadvantage of large corporations. It merely advocates for equal participation of all enterprises in a viable competition. Equal participation enhances the competitive spirit of several enterprises operating on level playing ground, which consequently impacts on the growth of the economy. The antitrust regime in India is relatively young, and hence most trade associations and MSMEs are unaware that the legacy practices which have become a way of business for them are illegal. The government, in order to reap maximum benefit of the huge market, need to ensure balance between robust administration and market-friendly regime. Going forward, the developing jurisprudence coupled with the CCI's increased focus on outreach programs will surely help to change attitudes among associations and increase compliance. The PhD Chambers is willing to partner with CCI for the programs to create such awareness and ensure effective compliances. Ladies and gentlemen, on behalf of PhD Chambers, I once again welcome you all and look forward to your active and valuable participation in this important session. I'm sure we all shall greatly benefit hearing the views of our outstanding panelists who are experts on the subject. Thank you and Jai Hind.
Thank you very much, Senior VP. That was indeed a wonderful of the competition policy, and a sound competition policy and an effective law enforcement not only protects businesses and consumers from anti-competitive behavior that can serve as artificial barriers to entry. So with this, I think we move ahead very quickly to request our chair, Mr. Naveen N.D. Gupta, to kindly give the chair's remarks. Over to you, sir.
Thank you, Vivek ji. On behalf of PhD Chamber of Commerce, I extend a very warm welcome to all the participants today. The very respected Pradeep Multani ji, Senior Vice President, PhD Chamber of Commerce and Industry. Sir, we are honored by your presence today. Very respected Dr. Sanjay Kumar Pandey ji, Advisor Law and Head Advocacy Division, Competition Commission of India. We are really honored by your kind consent that you have given and made your presence today. I have seen and worked with you while you were OSD and PS to Shri Arun Jaitley ji as Corporate Affairs Minister, and I know to the extent to which he used to give great importance and notice to your able advices that you used to give on a regular basis. Very respected Dharinder Kumar ji, founder, chairman of Competition Advisory Services LLP and former chairman CCI. Thank you, sir. We will be really enlightened by your pearls of wisdom that you would be sharing with us and great experience that you have. We are honored by your great presence today, sir. Vivek Agarwal ji, partner, competition law, DMD advocate. Ms. Aditi Gopalakrishnan, partner, AZB and partners. You have been with us on earlier occasion, and we know the extent to which you have great love and affection for the chamber, and we really admire your knowledge that you shared with us, and you introduced us to this subject. And because of your introduction to the subject, and because of the great demand that we had from the members, today we are again organized today's program. Our own Sharma ji, Head Competition Law Policy Practice, Vash Associates, and our own co-chair, Saurabh Sanyal ji, Secretary General PD, PhD CCI, and Vivek Sehgal ji, and our own Sohail. Thank you everybody for making it today and making this program great success. As we all know, competition brings out the best. It's always said, and healthy and constructive competition is always good because it is said it brings out efficiency. It makes a person and businesses and corporates effective and drives innovation. But change is the only constant, and in today's time of COVID, we have seen businesses struggling to survive, And because of this reason, we have seen increased number of cartels and unfair trade practices, unhealthy competition, and which has really been a cause of concern today. And we have recently heard Minister Gadkari ji raising concern on certain predatory practices, crisis cartels, which has led to increase in steel prices. And his concern was also genuine that with this increase in steel prices due to unhealthy competition, there would be huge cost overruns in the national investment pipeline, which is overall the project which is very much important for the growth of our economy. So frankly speaking, today, uh, in this new normal and new business practices, uh, businesses are really working hard to survive, to sustain. And we are seeing good businesses have become weak and weak businesses have become bad. And this has really led to bad competitive policies. So the awareness about the competition law become more and more important. And particularly so, there are the new businesses that those are coming up. So it has also led to predatory acquisitions that we are seeing, particularly in e-commerce field. And these monopolistic situations are also not good for the economy. So in this entire, I should say, landscape, the today's seminar webinar has been conceived and organized, and we would be understanding the growing concerns and the solutions and the compliance atmosphere that we as a business should develop to take care of the unhealthy practices which may impact our businesses. And towards that, I should really admire that the level of advocacy that Competition Commission has uh, done and the model that has been developed under the leadership of Sanjay Kumar Pandeyji, that is phenomenal. And that has really created concern and competitive, I should say, a compliance environment towards competition law in all good businesses. And in this direction, the today's webinar has been organized, and I should admire that the entire team of PhD CCI Corporate Law Committee, my co-chairs, uh, PPA Rastogi ji, Asim ji, Ranjana ma'am, have structured the program very well, and we have some very experienced uh, people to share their pearls of wisdom today with us. Dhaninder Kumarji would be taking us through efficacies of competition law in very, very relevant digital economy, which is the, I should say, mode of doing business in times to come. And then we have our own M.M. Sharma ji, who would be uh, sharing his wisdom on data privacy and its impact on competition. And Aditi Gopala Patel ji has been with us on earlier occasions also. She would be talking and sharing her knowledge as regards the latest trend and how to ensure compliances as far as competition law and enforcement is concerned. And then we have with us Vivek Agarwal ji, who would be enlightening us on benefits and risks of competition law for MSME. So all in all, as our leader Pradeep Multani ji has mentioned in the beginning, that this is a very, very relevant and current topic, and whosoever won't be attending, that would be to his or her parents. But I'm confident that PhD Chamber of Commerce and Industry, one of the oldest chamber, who is an active voice for particularly MSME in industry, and we know as far as competition law is concerned, the level of compliance and the awareness regarding these law is minimal, because generally it is felt that this is a law of very large corporates. But today we would be understanding the nitty-gritties of this law and how we can improve our businesses and make sure, because ultimately the market forces, that is the demand and supply, leads to healthy competition and emergence of good business atmosphere. And anybody and any practice which tries to disturb these market forces of demand and supply through cartelization or predatory acquisition is not good for the economy and should be discouraged. So in all, I am confident with today's webinar and the pearls of wisdom that would be shared by all the speakers and our chief guest, Dr. Sanjay Kumar Pandey, who would be delivering keynote address. We will all go back happy and more enlightened. Thank you very much. Thank you everybody for their great presence. Thank you.
Swastiki sir, we will welcome you to give the team access, please.
Okay. Senior Vice President, PhD Chamber of Commerce, Mr.
Hello.
Pradeep Multani ji. Dr. Sanjay Kumar Pandey. Am I audible? Hello.
Yes, please, you are, sir. Please continue.
Dr. Sanjay Kumar Pandey, Advisor Law and Head Advocacy Division, Competition Commission of India. Shri Dhirendra Kumar ji, Aditi Gopakrishnan ji, Mr. Vivek Agarwal, Mr. M.M. Sharma, Mr. Asim Chawla, co-chairman of the committee, Ranjana ji. Very good afternoon to all of you. May I begin with a little background of the Competition Act as to how it came into being, so that particularly the audience will be in the right perspective. In the right perspective, they will understand the nuances of the Act and how it has really been instrumental in shaping the economic laws. Particularly, this is a very important piece of legislation in this economic field. Sir, after economic liberalization was initiated by our late beloved Prime Minister Shri Narasimha Rao ji in 91-92, a need was felt to introduce a modern economic law in place of MRTP Act on the lines of similar laws in the other developed part of the world. Since it was widely felt that MRTP Act had outlived its usefulness. In 1990, Finance Minister in his budget speech stated, quote, "We need to shift our focus from curbing monopolies to promoting competition," unquote. Emphasis was on promoting competition. After completion of due process, the Competition Act 2002 was enacted on 13th January 2003, perhaps owing to because of this date of enactment that it ran into legal hurdles and finally it could see the light of the day almost after about 8-9 years. And in May 2009 only it really became the real act, because before that it was not operationalized. Owing to time constraints, not getting into the debate of MRTP versus competition law, except that MRTP really stifled growth and therefore was not in sync with the changing business dynamics of the time. The key elements of the Competition Act are: it ensures fair competition in India, it prohibits trade practices which cause appreciable adverse effect on competition, it protects interests of the consumers and to ensure freedom of trade. It is believed that fair competition makes enterprises more efficient and offers wide choice to consumers at lower prices. This ensures optimum utilization of resources. Therefore, competition is beneficial for the society since it induces economic growth. Going by the objectives of the Act simpliciter, it sounds very well and reads very well. After about 10 years of its existence, we now have to see whether the Competition Act has really done anything in the areas of promoting interest of consumers, promoting free trade, promoting competition, and thereby creating economic value. Or instead of doing anything better, it has created more hurdles, delayed the process of industrialization, and thereby delaying creation of employment and creation of economic value, etc. Although I am not going to be judgmental, instead I would leave this to the experts on the panel to enlighten the constituents of the PhD Chamber of Commerce and those who are participating in this webinar as to whether the Competition Act in its 10 years existence has lived up to the objectives for which it was enacted. If not, can we come out with some suggestions so that it promotes industrialization and create jobs through fair trade practices? Because I know our panelists are very, very experts and they have huge experience in this area. So we will have the benefit of they coming out with some suggestions for further streamlining the scheme of the Act. Hence this suggestion. Unfortunately or fortunately, with my 40 years experience in the corporate miscellaneous matters, I feel that while the objectives of any legislation or statute may be for the wider good of the society, however, owing to certain exigencies, sometimes it takes extraordinarily longer period of time before the statute or the regulations end up promoting industry and economic growth. We have seen how MRTP had stifled growth. We have also seen how reservation for small scale industries had killed innovation and the quality, etc. It is in the same context that from time to time, concerns have been voiced with a view that the Competition Act should do more good to the society and live up to its objectives and expectations. Some instances of which which come to my mind are that late Shri Arun Jaitley ji, as finance minister, had warned CCI of dangers of promoting hyper competition, thereby putting undue pressure on the rivals and even destroying the industry. This was in the context of unrealistically low bids in certain government tenders. As a matter of fact, sometime in June 2018, Secretary Ministry of Corporate Affairs observed that Commission should work like and as a tribunal felt that industrialization of employment. Before I conclude, I would also like to highlight some of the points our panelists may cover in their presentations for the benefit of all of us. Penalties are put in place with a view to ensure that penalties are not disproportionate. The cement industry. Some key players were levied aggregate penalties of as high as rupees 6,300 crores. Some of the industry players who are facing these penalties have already run into financial difficulties. Although the reasons could be altogether different, but still I feel there is a scope for some rationality before penalties are imposed. If these penalties are to be implemented, believe me, I have no doubt that for levying penalties or whether it follows certain logical pattern for levying penalties. I would request our with this and enlighten our constituents or the process of laying penalties or whether there are certain guidelines or they are just put arbitrarily. I would also like our panelists to also sensitize the audience about scope of the act to levy penalties on individual office bearers of the parties to cartel, etc. Sometimes this really can cost managing directors and other office bearers very dearly. Their income returns are also sometimes called for, and it really puts them off the track. I find that as per the scheme of things, there is no cooling period once an order is passed by CCI about there being no cartel in any industry. I am aware that a large industry was freed and a clear order was passed that there was no cartel. Ink had hardly dried on the order, and yet the investigation started based on complaint of a disgruntled, just because, maybe because there are certain vested interests at play, but I feel that there should be a cooling period. Once an industry is given a clean sheet that there is no cartel, investigations can start at least, not from the next day onwards only. Trade associations play a very important role on the overall development of any industry. I find the role of such associations often comes under scrutiny by investigating officers of the Commission. May I request the expert panelists to broadly advise us what precautions we as partners of the trade associations can take to stay on the right side of the law. Further, I find that CCI has strengthened leniency norms both for the entities as well as individuals, and lower penalties can be imposed if full and vital disclosures are made before commencement of investigations. Also, whether having a compliance tool or mechanism in place by an entity would warrant lower penalty. I would like the panelists to enlighten us so that we can have this kind of tool in our entities. It would be great if these aspects are also covered.
Mr.
Lastly,
Rastagi, sorry for interruption. Actually, Dr. Pandey
this is the only last one point, sir. Lastly, we have read recently about dawn raids on certain cement manufacturers. I wonder whether time of this webinar will permit the panelists to deal with all these areas. I will leave this to them only. Without taking much time further, I would conclude here and leave the platform to esteemed experts for listening, to whom our constituents are awaiting. Thank you very much. Sorry, I may have extended, but I think this is a wonderful opportunity for me to highlight the concerns of industry, since I have been witness to many transactions before the CCI. Thank you very much indeed.
Thank you. Thank you, Mr. Rastagi, for outlining your observations and, of course, the areas where you feel panelists and other experts need to throw light on. We'd like to quickly move on to Dr. Sanjay Kumar Pandey, Advisor Law and Head Advocacy Division of the Competition Commission of India. Sir, once again, let me welcome you heartily at this webinar. Allow me 2 minutes to read out your profile, please. Dr. Sanjay Pandey is academically oriented professional and an expert in trade and competition law. He has done his doctorate of philosophy, that's PhD, in the field of law from the National Law University. He has joined Competition Commission of India as Joint Director in 2010 and then worked as Director from 2015. He is currently, as we said, the Advisor Law and Head at the Competition Commission of India. Earlier, he was the Reader Law at the Amity Law University, GGSIP University, Delhi, and Assistant Professor at National Law University, Jodhpur for around 8 years. So a quick mouthful it was, and we can't wait to hear Dr. Sanjay Kumar Pandey. Over to you, sir.
Thank you. Thank you very much for kind words. Sri Pradeep Multani ji, Senior VP, PhD, CCI. Sri Naveen Gupta, Chair, Corporate Affairs Committee, PhD. Sri P.K. Rustagi, Co-Chair of the Corporate Affairs Committee. Sri Vivek Agarwal, distinguished panelists, experts, and participants. Namaskar and a very good afternoon to you all. My gratitude to PhD CCI for having me here today. It is a great pleasure to be part of this virtual webinar on recent developments in competition law. a first of its kind, I believe, by the Corporate Affairs Committee of PhDCCI, and I congratulate the committee for this initiative. I
Yes, sir.
also know, I really admire that PhDCCI does needful for the MSMEs, and Competition Commission of India has a big role in empowering our MSMEs and bring competitiveness all around. That will be a great thing to partner with PhDCCI and do a whole lot of awareness work as well. Let me begin with a usual disclaimer. Views expressed, opinions formulated, or interpretations advanced by me on this platform are my personal understanding, and it is not the view of Competition Commission of India or the Government of India. We all gather public information, and definitely whatever I have learned, I love to share with you all. As we all know, markets are dynamic, and so is the competition law. Given the extraordinary circumstances caused by COVID-19, and we have all witnessed that, the way competition law has steered the markets globally shows dynamism of competition law and the competition authorities. The innovation in health sector to overcome the pandemic has shown resilience, and the affirmative support of antitrust authority internationally have resulted in a lot of efficiencies. CCI is back to pre-COVID functioning, but it allows even today parties to continue filing electronically and also conduct virtual hearings of the cases. Friends, there are more than 130 jurisdictions across the world today that have some or other form of competition law. As a philosophy, competition law ensures level playing field for all enterprises, promotes vibrancy of economy, and enables common man to reap the benefits of growth. COVID-19 has given an opportunity to reassess working of national economy and reflect on the emergence of digital economy across the nations on a wider scale. Digital economy, e-commerce, or say platform markets sound similar tones in almost all jurisdictions, and so similar concerns on the regulatory maps across the world. Considering the available time for the sake of brevity as well, I have picked up some of the antitrust developments in India and abroad for discussion today. These are not detailed, but good enough to flag issues for further reflections. In the Indian context, we all talked about the CLRC recommendations, and today the presidential address has referred to CLRC. Mr. Rustagi was talking about a lot of needs in competition law paradigm. Now, no doubt that CCI has had a decade of enforcement experience and more than a decade of advocacy experience, because Act came in 2003 and thereafter advocacy has gone on a big scale and is still going on in different contexts and different tone tenor. Now, the CLRC recommendations are far-reaching, no doubt, and provides a recast of organizational structure along with additional elements to robust, create an environment for robust enforcement of competition law in the country. The CLRC recommendations, many of which we see they have passed in the proposed competition amendment bill as well. On the combination side, what we are expecting, as flagged by many here, and the panelists will appreciate, that shorter time period for scrutiny of combination cases, even for CCI to render its final decision in combination matter has to go down, and it will be we'll have to wait for the time to see the things are put in perspective. As of now, there is no straitjacket formula to determine control in transactions when we are referring to combinations. There is also an intent to widen the spectrum of control to include material influence, resulting in an ability to control the management of the affairs of an enterprise, so that transactions do not escape the competition scrutiny. The change would definitely empower the CCI to examine these transactions, even if the assets of sales thresholds are not met. Another major development on the combination side, which we all have seen, the Commission has recently amended the combination regulations to dispense with the requirement of providing information on non-compete arrangements in Form 1. This amendment provides flexibility to the parties in negotiating non-compete clauses. Thus, the parties are not bound by general set of standards for assessment of non-compete restrictions, which may differ from case to case. This measure will also reduce the information required at the time of notifying the combination, a good step towards ease of doing business. As we all know, Green Channel is introduced and has completed more than a year now, is a path-breaking reform for deemed approval of combination. The Green Channel should not have horizontal, vertical, or complementary. Today, what we find that one out of every 5 cases filed in CCI under combination regulations, they go under Green Channel. This demonstrates greater stakeholder confidence. I must emphasize that this is a first of its kind trust-based system in the world and sustains speedy, transparent, and accountable merger review. It also strikes a balance between compliance and also supports economic growth. No doubt the Green Channel has made the merger regulations quicker and more efficient. Now, we heard referring about leniency. Now, CLRC differently has referred about leniency upgradation, and it talks about leniency plus mandate. With leniency plus, a company that pleads guilty to a hardcore antitrust violation, such as price fixing or bid rigging, may receive reduced penalties if it provides information that enables the antitrust agency, that is CCI, to take action in other markets. The company and its executives usually receive immunity for self-reporting these additional cartels. Now, we are contemplating something new to the competition regulation regime in India, that is settlement and commitments, to enable faster resolution of cases and to meet the larger goal of market correction. The proposed amendment carries a provision for settlement and commitments. These mechanisms, once put in place, will allow for speedy resolution of cases and swift market correction. They will allow those found in contravention of the competition law to commit to correct their ways to avoid further action even before the investigation is completed. Such a mechanism will facilitate ease of doing business in the economy. The definition of cartel shall incorporate hub and spoke misconduct where a common supplier or a manufacturer coordinates price fixing among downstream competitors. This is directed at any enterprise or person that actively participates in furtherance of an anti-competitive agreement, regardless of whether they are engaged in identical or similar trade. A recommendation also expands the definition of cartel to reach buyer cartels, where competitors agree to restrain competition in the supply market. Advocacy, I'll refer to advocacy developments, what has happened. We know that advocacy is the oldest limb and oldest pillar of CCI domain. And we have been doing advocacy since the act has come into force. In order to broaden the reach and disseminate the idea of competition law to states, CCI launched a scheme named State Resource Person Scheme. And today, 23 states are and 1 UT, they are partnering with CCI under this scheme. This scheme was launched in 2020 and has completed recently 1 year. This endeavor was imperative for imparting training to state government officials in general and procurement officials in specific. In furtherance of this objective of the scheme, CCI has conducted so far several advocacy programs for the procurement officials under the SIP scheme, and responses of the participating states have been overwhelming. The Commission has recently inaugurated Regional Office South in Chennai. in the August presence of Union Finance Minister. The regional office is a step towards augmenting CCI's regional presence and fulfills its duties as a federal regulator by engaging closely with the states, being important stakeholders in fostering greater competition in the economy. The Chennai office of CCI will act as an office to facilitate enforcement, advocacy, and do a whole lot of facility providing provision for stakeholders. The regional office is designed to cater to the requirements of the states of Tamil Nadu, Kerala, Karnataka, Andhra Pradesh, Telangana, and the union territories of Puducherry and Lakshadweep. The Commission has come out with two market studies recently involving telecom and e-commerce. As we know that e-commerce market study has been accepted by many stakeholders, and it has flagged many issues like lack of platform neutrality, unfair platform business contract terms, existence of platform parity clauses, and exclusive agreements for the deep discounting. And it is felt that while many of these issues may be examined under the provisions of competition law, what seems to lie at the core is an imbalance in bargaining power between platforms and business. So Commission definitely looks from the advocacy, self-regulatory, as well as enforcement aspects to do the needful in this sector. On the telecom study, we must have seen, it is on public domain, the competition concerns that emerge in telecom study include data privacy, role of combined data power to establish dominance, issue of spectrum ownership, infrastructure sharing and unbundling, and net neutrality and network effects. I'll be glad to add here that CCI has also initiated pharma sector study. The ongoing pharma sector study focuses on the distribution segment of the pharmaceutical market in India with a view to understand the discounts or the margins at wholesale and retail levels of the distribution system, the role of trade association, and this is in contrast to the aspects of distribution business, regulatory rationalization of trade margins, and its impact on price and competition, the impact of e-commerce on price and competition. Besides, the study also aims to investigate the extent of proliferation of branded generic drugs in India, with its implication for competition, and to assess potential hurdles, if any, in entry of bioequivalence in India. I would like to add few international developments in this chain in the antitrust area as well, which are almost in sync globally. We all have seen that apart from the big tech congressional hearing in the US, mobile application developers have filed antitrust class action lawsuit against a tech giant, alleging a number of concerns. In another case, Department of Justice, together with 11 states, filed a lawsuit against Google. Definitely a lot of issues have been raised, and many countries also echo similar concerns what we are looking at. In Australia also, issues relating to tech giants are going on. European Union has opened a series of cases against a big tech company, and there are issues relating to various facets of antitrust. In Japan, the Japanese parliament passed the Act on Improvement of Transparency and Fairness in Trading and Specified Digital Platforms. The Act requires that a specified digital platform providers improve transparency and fairness in trading on their digital platform. Now, definitely this Act has to undergo some changes. I believe they have to identify what amounts to specified digital platform providers and how they're going to take up. I'll add some further developments on this fora, that is on UNCTAD. You may have heard that the UNCTAD has formed a working group on cross-border cartels. So there is a need felt at international level that competition authorities must think about having a system for cross-border cartel as well. So we happily await the outcome of this working group. At OECD, definitely at the OECD at the forefront of a lot of antitrust developments, new things coming up. And one of the latest things happening there is some work on women and antitrust. So this encompasses a whole lot of issues that women antitrust enforcers or women antitrust practitioners or things or goods which are under antitrust, which are women-centric, and so on and so forth. Well, as I have underscored some of the developments in the arena of competition law, further, I would like to flag a few challenges as well. And I found that some of you have echoed in your speeches. First is awareness. As you may be aware, and I emphasize this also, that CCI has been doing competition advocacy since its inception. In the initial years, CCI was faced with the key challenge of sensitizing its stakeholders about the new competition regime in the country. Being a complex economic law, the challenge was major as the key principles and requirements of law had to be communicated in a very effective manner to a vast spectrum of stakeholders. Given the change in market dynamics, industry functioning, and rising gains from competitiveness, the need of competition awareness and competition compliance has increased manifold. How to go about with limited resources is a big challenge, and it's a thing to look into and discuss about. Prioritization with increasing awareness amongst the stakeholders. That's also the realization on part of consumers. The filing before CCI will constantly rise. The surge of cases will require appropriate prioritization or sifting on part of the agency, which in turn requires a clear understanding of the sectors which warrant immediate and urgent intervention by the authority. Processes. Now, processes are driven by statute, and a lot of processes are to be designed by CCI. So the process adopted by the competition authority need to be dynamic in parity with the need of time. So how to comply with the statutory framework and be dynamic, that is also to be seen. On judicial review side, despite a well-structured three-tiered hierarchy set up with all India jurisdiction envisaged under the Act, various high courts have intervened in many cases in exercise of their power of judicial review to scrutinize the orders of CCI which are otherwise not appealable. This aspect of law, along with its finer nuances, are big challenge before the authority. Interregulatory coordination. This is another aspect which requires more deliberation. The role of competition agency and sectoral regulator. We believe that the role is supplementary and complementary to each other. However, the areas of the respective functioning need to be clearly defined and delineated. In case of conflicting views, mechanism may be required to put in place to resolve such disputes in an effective manner. A symbiotic relation between competition authority and sectoral authority would go a long way in developing, deepening, and regulating the markets, which ultimately would benefit the consumers apart from enhancing the economic growth. Another key area could be, as a challenge, I believe, is extraterritorial jurisdiction and international cooperation. As we all know, CCI has a very vibrant international cooperation regime, and we have agreements also with many of competition authorities. CCI has in the past looked into cooperation side, but when coming to invoke the extraterritorial jurisdiction, definitely we have to gear up because there is a mandate in the law that the extraterritorial jurisdiction with respective to transactions or conduct taking place outside India, but having AEC in India, this becomes a jurisdiction area. So definitely how to invoke and how to go about. That's definitely time is coming to look into this as well. evolving markets. The agency needs to gear itself up to face the challenges. The agency is definitely facing it and looking into the virtualization of economy, how things are moving and how CCI has to be proactive to look into the new issues. At the end, because I'm coming to the end part of my time, so I'll don't get into much detail about issues, but I'd love to hear from you all about new developments, what I'm trying to flag. So I would like to appreciate the efforts of PhD CCI in organizing this event and look forward to a productive outcome of this event. Such events not only help us to introspect, but also bring new ideas to current practice of competition law. I must reiterate that number of good suggestions have been articulated in the presidential speech and followed by thereafter. They will definitely help the stakeholders in taking informed decisions, and CCI shall endeavor definitely to partner with PhD CCI and take the competition advocacy further to all the MSMEs. Thank you very much. Namaskar, Jai Hind.
Thank you very much, Dr. Pandey. I think, and indeed, very comprehensive. I think message across to us is on the developments and the impacts which the recent developments and the impacts which it is making, starting from the green channel and the advocacy, and a whole lot of other things which you talked about, and definitely also taking up the issues raised in the previous speeches very categorically and very accurately. Thanks a lot for all that information. We have a few questions which had come to us on email also, which we would like to take it up at a later time with you during the program. I think it's time for us to call upon Mr. Dharendra Kumar, a person who's almost sought after, for sessions, and we are indeed very lucky to have him with us. And of course, in his capacity as a former chairman of CCI, I think he could also bring in very interesting aspects which would be very useful for the industry. And I see articles from you, sir, I think floating around in all the major dailies, whether it is the PLI scheme or whether it is anything else. So good to have you. And in the interest of time, if you permit, I will not read your profile because I don't think you need any introduction, sir. Over to you, please. Sir, you are muted. We can't hear you. Kindly unmute.
Thank you, Vivek ji, for a very nice, warm introduction. My friend, Mr. Pradeep Multani, Mr. Rastogi, and my former colleague, Dr. Sanjay Pandey, Mr. Naveen Gupta, fellow panelists, and distinguished friends. I just noticed when I was listening to the enlightened speeches so far that there are 99 participants and most of them I know. So I'm delighted to have nearly 100 participants in this virtual webinar. I compliment PhD Chamber for this. In fact, it is exactly after 10 years I got this opportunity to address PhD Chamber. I first addressed this chamber in 2011 when I was chairman CCI. So it's a pleasure to come and speak to you after 10 years. Friends, when I joined as chairman CCI in February 2009, some friends congratulated me, telling me that congrats, you've got a new assignment. By the way, what do you do? They didn't know what the Competition Commission was. And some of my friends from industry like you, they told me that we had enough mothers-in-law earlier. We had the CBI, we had the C&AG, we had various other bodies. We have another mother-in-law added to the list, what is the CCI? I had to tell them that this mother-in-law is a very affectionate mother-in-law which tries to help the daughter-in-law, and it would be helpful to you in a number of ways. And I try to explain that first of all, as the preamble says, the idea is to promote economic development and also to protect the interest of consumers. And in the present era, everybody is a consumer. All of you from industry know that you buy raw material, you buy services, you are a consumer, and you give your end product to somebody, then he is a consumer. So in the value chain, everybody is a consumer. So if the efficiency of the value chain improves, the consumers benefit by virtue of lower prices, by improved products, by technological innovations, then we have an economy which is dynamically improving. So there are static and dynamic efficiencies built in the system by virtue of competition. And it has been proved globally. Economic matrices, economic theories clearly bring out that competition benefits in a number of ways. And it has been benefiting every economy, every industry, and every country, which can be discussed and seen later. But coming to the present theme, which is the digital economy, how can competition law function, improve, help the players in the digital economy? Let us talk about this digital economy for a while. Digital economy, which is also known as the new economy, and it has shown during the pandemic how it has helped us. It has helped in pulling through this abnormal state of affairs in terms of the daily lives, in terms of everything. And not only the pandemic era, in fact, the whole world and the economy has been changing so fast. If we look at how the economy has been developing, economy has been developing in a disruptive way also at times, disruptive technologies. And I'll give you just a few examples. I know that we are short of time. In 1998, Kodak had 1.7 lakh employees, and they had 85% of the world's entire photo paper business. Whenever we used to travel, you would remember, I remember that from the duty-free shops, we used to buy those reels for our cameras. Now, within a couple of years, the whole thing became history. With the advent of digital photography, the entire business of Kodak, it was finished. I remember when I went to Los Angeles, the Kodak theater was the one where the Hollywood used to have their various annual functions. But now Kodak, nobody knows. Same thing happens in a number of ways. The artificial intelligence, it changed the way things happen. In fact, the IBM Watson, it has come up with models that very soon the legal fraternity, the doctors and everyone, probably they would also become redundant. And it would not be far away when companies like Tesla and Apple, they would make the transport sector completely different, the automobile industry, the self-driven cars and so on and so forth. The technology is changing very fast, and that is largely because of digital economy. Digital economy is making the earlier models and earlier industries obsolete. In a situation like this, it is necessary that even the competition law and the other regulations also keep a track in order to regulate the economy in a manner that this would improve the economic outcomes. And that is what is going to happen. If we look at the state of economy which came up during the pandemic era and how the digital economy helped us through, just for a couple of minutes. In terms of e-commerce, you would have seen that the delivery of goods and services at doorsteps was a big help. Otherwise, the pandemic wanted all of us to remain indoors and maintain social distancing. E-commerce helped in a big way. Teleconsult helped in a big way. Delivery of services helped in a big way when we could get, thanks to the various firms in this field, getting our barbers and our beauticians and our services, plumbers and everybody at our doorsteps. Similarly, in the field of entertainment, we could have then in the field of delivery of food, Zomato and so on. So all these applications came on the digital platform, and it was obvious that during this 1 year that it was the digital economy which saw us through. And during this process, the invention, or whatever you may like to call it, the vaccines also was a great marvel. Normally, we used to be told that any vaccine would be developed in 4 to 5 years. Now, we had a vaccine which was developed in less than a year, which was another technological marvel. Bill Gates, in his celebrated book, wrote in 90s, Business at the Speed of Thought. So he predicted at that time that in future, business would have to be conducted in a manner and only those companies would succeed who are able to do their business at a speed of thought, futuristic thinking all the time. Now, our regulations, which have been designed on the basis of earlier models, obviously cannot keep pace with the advent of technology, and therefore the government and the CCI, they also took measures to upgrade their regulations, and therefore, as Dr. Sanjay Pandey said, the Competition Law Review Committee, it was set up under the chairmanship of the former Secretary Corporate Affairs in Jyoti Srinivasan, and all others were members, the chairman CCI, number of others, even I was there too. They came up with their recommendations, and a new legislation is under draft, not legislation, amendment in the competition law, which would probably come in before the parliament, and there could be a number of new changes which would pertain to the regulation in terms of businesses of data. Data has become extremely important. Data, in fact, as they always say, data is the new oil. But it has a number of positive factors. It has a number of limitations. It is necessary that Competition Commission, they also look at it. Now, I'll just briefly mention about a few things relating to the new age economy. The Competition Commission conducted a few studies, as it was just mentioned by Mr. Sanjay Pandey. The one study which came out in January last year was on e-commerce, and Amazon and Flipkart. They were the subject matter of a few litigations thereafter, because soon after this study came about, there were a number of factors which pertain to the price level, and also in terms of whether you have specific or special relationship and so on. So there was a case which was filed in CCI, and that case is still going on. I am not trying to say that those cases were right or wrong, but CCI was faced with a number of such cases in e-commerce sector. There were cases in the transport sector against Ola and Uber. There were cases in the pharma sector, and so on and so forth. In those cases, it was brought out that the earlier rules which pertain to Section 3 anti-competitive agreements, horizontal or vertical, or Section 4 abuse of dominance, and Section 5 and 6 which pertain to combinations, probably they need to have a fresh look at. For example, in the case of combinations, Section 5 and 6, it was noticed that some of the major players, they sometimes acquired, bought over some of the small and emerging players in order to eliminate competition, which was also known as killer acquisitions. And some of the very big, the major companies, the FANG companies, as they call it, Facebook, Apple, Google, and so on, they have also been doing it in the past. So whether in those cases, the earlier parameters where the Competition Commission only looked at the size of the assets of the acquiring companies, they would be the relevant part, or they should look at something different. Just to illustrate, when Facebook acquired WhatsApp in 2012, 2014, the value of WhatsApp was not even $1 billion, but they acquired it for acquired it for $19 billion. Imagine Facebook buying WhatsApp at $19 billion when the value at that time was much less than $1 billion, because it had potential of large volumes of data. And WhatsApp has now almost 54 crore users in India. And imagine the enormous data it could have. And now there are talks of integrating that data in the Facebook, with which there would be multiplication of data. Now, in India, it was not even applied for approval, this acquisition. Why? Because the size of that, the assets, did not warrant that it would be sought for the approval in Indian competition law. So therefore, there is a talk that there should be, the definition should be changed, and the size of the deal, if the size of deal was supposed to be the criterion, then $19 billion size would have made it eligible for being reviewed, and then the Competition Commission could look at the possible implications of that. But having said this, I'm not suggesting that this deal should be blocked in any manner, should have been blocked in any manner. But the point I'm trying to make is that in the change scenario, when data is important, then you have to see whether the earlier rules, earlier gates were relevant, which were relevant earlier. Are they relevant still today, or we need to have a fresh look at it? Again, say in Section 3, anti-competitive agreements, whether those kind of agreements would be relevant today. Section 4, abuse of dominance. Now, in a situation like this, whether you would call them dominant or not, again, something which would you would have to look at it, because the relevant product market and the relevant geographic market, the definitions would need to be changed. Would need to be changed because we have a cross-sectoral, at times cross-country territory, which could be relevant. In any case, a smaller set of things, a smaller geographic location may not be exactly relevant in a situation like this. So in the change scenario, in a digital economy, when everything is dependent on the use of digitalization, digital economy, it is important that we look at the implications or impact on the market, the way market is functioning in a situation when Section 3, Section 4, Section 5 and 6, the spirit of those sections would be relevant today. Coming finally to MSME sector, where the PhD is generally known to be the voice of the MSME sector. Let me tell you that the Competition Commission globally is considered to be a great friend of the MSME sector, because they are generally attuned to genetically protect the interest of MSME sector from being exploited against by the larger sectors. So the entire philosophy of the Competition Commission is designed according to those principles. I may also tell you that the Competition Commission at times, it can be beneficial to the MSME sector or generally to the industry in a number of other ways. For example, if there are global cartels and those global cartels have resulted in increase of prices which have adversely affected the MSME sector or the industry in general. And globally, let's say in London somewhere, that cartel has been subjected to some penalties, fines have been imposed. Now those fines, not only the victims of those cartels in those countries can claim for compensation. In Indian competition law also there is a provision that victims who have been injured by these practices can claim compensation, and they can claim compensation in those territories also by virtue of the agreement which we have and the section 32 of the Indian competition law, which allows the Indian Competition Commission to look at the harm in such cases. So I wouldn't like to go into the nitty-gritty of many of these things. All that I'm trying to say, kindly don't look at the competition law in India as another barrier, another mother-in-law, which would be there to create problems and hurdles in your way. It can be useful, it can be beneficial, and the attitude of the Competition Commission these days, I can tell you, although Dr. Sanjay Pandey is here, he would be able to allude it to much better this thing, that they are very helpful, they are very proactive, and they have not been taking any unduly adverse view in such matters. Having said this, my last and final word would be that the best practice would be adherence to the competition law and the compliance. So for the compliance, these studies which have come out, the last one is on pharma. And I've gone through that study in detail, number of good features. One can suggest to the industry, the pharma associations, how they can make themselves adherent or compliant to the principles of competition law without spending anything or changing their rules and regulations in a substantial way, or similarly earlier in the e-commerce sector and so on. So altogether, the best way to proceed today would be to get compliance study, compliance audit conducted in your industries and in your associations, trade associations in particular, I would say. In fact, I wrote a big paper along with a friend of mine, Professor Rahul Singh of NLU, and that paper was published globally in various journals. So we specifically alluded to it, how trade associations need to conduct their businesses globally, because now it's a global competition or antitrust law, in order to stay on the right side of their competition or antitrust laws. As it was just mentioned, there are now nearly every country has got a competition law, over 130. So it would be useful to abide and to remain attuned in accordance with the competition law. Thank you very much. I am really grateful for this opportunity, Mr. Sehgal, and I am one of your members on the managing committee. I would always be available to you, and it would be a pleasure for me to be of any help to any of your members, pro bono, to be of any help in adhering to the competition law. Thank you very much.
Thank you very much, sir. Thank you indeed. And not only as a valued managing committee member of PHDCCI, you're also such a fantastic and a helpful person that is, as you said, eluded. I would like to use that word, eluded by your last statement. So kind of you, sir. And I think two very important messages coming across. The competition law is always a friend of the MSMEs, and good relationships between the mother-in-law and the daughter-in-law is to be expected. And this assumes great significance, this MIL and DIL, as I like to call it, relationship, especially in the Indian scenario. So thank you so much, sir. I think time for Senior VP, I think, wanted to say something.
All I wanted to say was to Dhanendra ji, firstly, of course, he's my senior and we have the greatest respect for him. But when he said your members, I wish he had said our members. Because he's a part of, but he's a part of the PhD chambers. So Dhanendra ji jab kehte your members, thoda, actually our members. And we know we are always there for us. Thank you very much for your support, sir. Thank you, sir.
Thank you.
Thank you. Thank you, Senior VP. I think it's time for us to hear Mr. Vivek Agarwal, the partner at the competition law at DMB Advocates. I think he'd like to speak on benefits and risks of competition law for MSMEs, I think, which is the logical extension of what Mr. Dhanendra Kumar just talked about. Over to you, if I can call you namesake.
Thank you so much, Vivekji. I've been asked to focus on MSMEs in this session, but later on the request was that the audience is going to be slightly broader. So for those of you who don't call yourselves MSMEs, the good news is that everything I'm going to say here is going to be as relevant to you as it would be to an MSME. So don't think the session is going to only focus on MSMEs. But PhD chambers, like one of the very few chambers which focus on MSMEs, so I will try and kind of focus on issues which are also relevant for MSMEs. And I say that because unlike certain other countries like UK, Germany, India does not really create any exceptions or have different competition rules for MSMEs. This basically means that as long as you are engaged in any economic activity, all rules will apply to you, irrespective of your size. But if you are a large player and you can be considered to be dominant in any market, you would have a special responsibility to be extra careful with your conduct to ensure that your competitors or business partners are not unfairly disadvantaged by your actions or policies. So in the next maybe around 20 to 30 minutes, I will try and keep it to 20 minutes. I know we are running little over time. What I would do is I would focus on a few key issues which are relevant for MSMEs. This would include both the issues MSMEs may face from larger players and the risks of non-compliance they need to be wary of. But before I jump into this discussion, let me make a few quick remarks on recent competition law developments and trends which actually stand out for me. I wonder if one could talk about recent developments and impact and not talk about the pandemic or digital markets, which have been our lifeline during the lockdown. And although Mr. Kumar has already spoken about competition law and digital economy, I would make one quick remark, which has been a live issue across the globe. That are the current competition rules capable of dealing with issues arising in digital markets? And they do operate differently from traditional markets. In India, we follow a rule of reason approach, and the standard is AAEC. We keep hearing this word very often. It's appreciable adverse effect on competition in India. Such approach in principle, at least to my view, should be capable of dealing with any situation, even those situations which are not contemplated by the draftsman of the competition rules. But experience tells us a few instances which have highlighted the need for correction. And I think Mr. Kumar did touch upon a couple of them. One of them is turnover and assets-based jurisdictional thresholds which trigger combination filings in India. We have seen that these thresholds may not be best suited for digital M&As, and a few large transactions like Microsoft LinkedIn or Facebook WhatsApp escape CCI's scrutiny. But the proposed amendments to the Competition Act have tried to address these issues by making a provision for other criteria, which may include deal size-based thresholds. Another issue could be defining of relevant markets for digital services, especially those which do not require monetary payment. And I won't call them free, because in most cases you do pay through your personal data, if no other means. Relevant markets are traditionally defined based on substitutability in products and services. And the substitutability is primarily determined based on increase in price. Sometimes in competition law parlance, it's also known as SNP test, which is small but significant non-transitory increase in price. But in case of digital services, market definition, becomes a little difficult based on SNP test, because there is effectively no monetary price attached to availing of that service. Data and privacy are other common issues which keep popping up in the digital world, but both are addressable in the current framework. At least to my issue, data can be, fit in the size and resources while determining dominance, and privacy is also an issue which can certainly form part of the broader abuse of dominance provisions which we have under the Act. So to address these issues, certain countries are contemplating ex-ante rules, but CCI's approach has so far been ex-post enforcement, except combinations. But in the recent telecom market study, the CCI acknowledged a balance is required to be struck between ex-ante regulation and ex-post enforcement. So this was the first time very recently when the CCI did say that, they might have to look at ex-ante regulations. I must also mention how the CCI has been demonstrating its maturity and confidence. It is commendable how the CCI managed its policy and working over relaxing the application of Competition Act, as was done in the West. The CCI held its ground and informally clarified that any exceptions that can be accommodated in the rule of approach, and no special rules were required. Any indispensable measure which was required was anyway taken by the government under the Essential Commodities Act or the Disaster Management Act. Although we had been hearing about how AAC was all about balancing the negative factors with positive factors, the focus generally has been on negative factors, but the pandemic created a situation where positive factors also assume significance, at least as far as quantification of penalties is concerned. And this issue has now stirred another debate on CCI's discretion in determining quantum of penalties, especially in cartel cases, which are considered to be the most pernicious violation of the Competition Act. In the absence of any guidelines on quantification of penalties, it still remains unclear as to how CCI decides on a penalty. But again, the proposed amendments should fix this, as the CCI would be required to publish some guidelines on quantification of penalties. Another important feature of the recent CCI practice has been market studies. And this is important because market studies is basically a feature of mature markets. And we have already seen two reports so far. One is e-commerce and one is telecom. Pharmaceuticals is ongoing. And there are at least two more which have been announced. One is on the digital M&As and the other one is on private equity. So, and market studies have always been an important constituent of functioning of mature competition law jurisdiction. And the CCI's initiative to review and understand multiple sectors in detail clearly indicate that the CCI is headed in the right direction. It reflects how the CCI is mindful about using its resources efficiently and provide more certainty and visibility to industry players. Now I'm conscious of time, and for me to be able to stay on the right side of my time limit, I will touch upon 2-3 issues which are relevant, which is one is bid rigging and briefly trade associations. And also I will touch upon resale price maintenance, which does come up in most cases. And then towards the end, I will also quickly touch upon the basic do's and don'ts in competition compliance. But before I get into all this, I think one key point which I would like to restate, which Mr. Kumar also mentioned about MSMEs, is that competition law is not merely something to be bothered about, call it mother-in-law or call it something which requires compliance. But this is also a tool which can be used by MSMEs to its benefit. And more often than not, MSMEs have to deal with big boys, and may it be a large competitor, a large supplier, or a large customer. And sometimes dealing with large players, frustration creeps in, and which prompts us somehow to fix the problem at our level. In many cases, many small players try to come together and better compete with the large player. This is when issues around cartelization, sensitive information exchange, collective boycotts, even bid riggings, all these issues start popping up. And I think the basic key to be on the right side of the competition law is a very simple rule that operate independently. In most cases, competition law does not allow small players to come together and fight a large competitor. If a large competitor is resorting to unfair ways to disadvantage you, the only solution is to complain to the CCI to get the situation resolved. And I've been faced with this question multiple times by my clients that, the other side is actually into a cartel, and there is some problem or some sort of anti-competitive conduct which they are engaging in. And there is no way we can effectively compete with such a party or such an industry. And the only way is that we all come together and just collectively boycott them or, engage into a similar activity. But if you try and do that, it is a very, very risky proposition, and you will find yourself on the wrong side of competition law and expose yourself to sanctions by the CCI. So my humble request is, I know you might face with a situation when, there is some sort of anti-competitive conduct and it may lead to a bit of frustration. But my suggestion and strong advice is please seek legal advice on that or approach the CCI. Please don't try to, do tit for tat in any way, because that is not going to be conducive in any way. Even if I have to take one example in terms of how competitors try to impact you, is they will try and cut your suppliers or cut your customers, by imposing, say, exclusivity conditions. You're trying to, perhaps you are a new player and you're trying to enter the market, and they will start imposing exclusivity on, say, customers, that if you deal with a competing product, or specifically target you, that if you start dealing with company X, which is trying to launch, we will not give you incentives, or we will cut your supplies. And then it becomes very difficult for you to compete with a large player. Similarly, in case of large customers, if you have a customer, the question is that if that customer does not deal with you, it becomes very difficult for you to even enter the market. So, there has to be some sense of fairness in terms of how that customer is going to determine who its vendor going to be. And in case you don't get access, there is always CCI, or seek legal advice and try and find a solution that if you are not able to enter the market, you feel foreclosed, there is always a solution. And if not just a solution to correct the course, but also you can claim monetary compensation if you go approach the CCI and the CCI finds a problem in what a large player is doing, whether it's your supplier, customer, or competitor. You also have the option to seek monetary compensation. If you have suffered any losses as a result of the conduct of a large player, you can approach the NCLAT with a finding of violation by the CCI and claim any monetary losses, compensation for any monetary losses which you could have incurred as a result of any anti-competitive conduct. So my suggestion is that don't look at competition law merely as yet another law or a mother-in-law which requires additional compliance and which is going to be a roadblock. But certainly, if you understand competition law well, you can use it to your benefit. You can use it to correct any industry issues because of a large player, etc., which might exist in your business. Now, coming to the compliance bit, I think I will very briefly touch upon bid rigging and trade associations along with MRP. And I think this is not rocket science, but I really want to, since Mr. Rustagi did mention that we should touch upon some of these, I think it is important to highlight what could be considered to be bid rigging and what are the key factors which are considered by the CCI while looking at bid rigging cases. And I think bid rigging is pretty simple. I think we all understand what bid rigging is basically any agreement to manipulate the bid process, and it takes various forms. Sometimes it's in form of bid rotation. In my slide, I've tried to put some examples that 3 or 4 players will come together and decide that the lowest bid would be put in by a pre-agreed winner, and other players will either not participate or there will be inflated bids. Then there is also bid rotation, which requires that bidders will actually participate either in different markets or in different periods, or allocate different customers. And in most cases, the customers happen to be government departments. So one player will participate in one state, other player will participate in another state, and therefore in each state there is no real competition. And there are also ways to have compensation for unsuccessful bidders in a particular market, and they divide profits and find a way so that there is no competition, and the prices to the customer, mostly government, is slightly higher. And this is rampant, I would say, and the cases have certainly gone up in the recent times, despite guidelines from CVC in terms of minimum number of bidders, etc. We still keep finding these problems around bid rigging, but one needs to be careful because MSMEs are generally small players and they have to kind of focus on kind of competing with larger players. And the best way is that if 3-4 players come together and try and compete with a larger player, it's always easier. But it is a very, very risky proposition, and if you think that you might get away with it, I would say that CCI has certainly become extremely sophisticated in terms of how they look at the evidence data, and it's more often than not, you will find yourself in trouble. And I'll give you some factors which have been considered by the CCI while dealing with bid rigging cases. And like there are similar prices, but if you look at each player, the cost data is going to be very different, or the quantities supplied are different, or the geographies are different, which may have different logistics costs, etc. Despite that, you will see the prices are very similar. There have been instances where the prices have been same to the second decimal point also. Then there are evidences in terms of documents, maybe your email trails, maybe your instant messaging. WhatsApp is become very, very popular thanks to television and SSR and whatnot. Everyone knows what's going on WhatsApp. It, in one way or the other, it does come out. There are call records, right before the tender submission, you will see that the calls between bidders have gone up. Even previous night until late night, you will see there have been long calls between bidders, and there have been very, very interesting instances, especially before the Director General. And recall one very interesting one where a party who was being deposed was actually asked and confronted with the call records and asked about what is this call you have made for half an hour to your competitor, because so far you have been saying that I don't know this gentleman or I don't know my competitor, and here is your call records, and you've spoken for half an hour to this gentleman the day before the tender was to be submitted. And the gentleman was taken a little aback, and his response was that I was sitting in Gurdwara and there was a bhajan playing. So I think it's my responsibility as a good human being to actually make random people listen to these bhajans and get closer to God. So I go to the Gurudwara and just dial a random number and keep it on for half an hour so that he can benefit from a bhajan which is sung in the Gurudwara. And of course, I mean, there was a penalty, but it kind of stuck to me when I heard that people just go blank in depositions. They are on oaths and they don't know how to justify because they think that they will say they don't know the gentleman and there is no evidence. But these things do come out more often than not because there are multiple parties involved. Even if you think that, you know, you can keep these evidences away, but you can't, someone will give it to the CCI. So I think, I mean, I won't say that, you know, try and keep the evidence away, but the best way is to comply, and I'll come to that. But other instances of evidences which have been considered in bid rigging have been the bids were submitted by different players who are competitors and claim not to know each other from a common computer. The IP address, everyone sat down at the same time on the same computer and submitted the bid. And this can be tracked. And there was common IP address. There have been payments of securities from a common bank account. And other interesting kind of instances have been same cover letter. If there is a typo in certain words, that same typo has been there in the cover letter filed by every bidder. There is an interesting instance again that where DJ actually said that you all turned up at the office sharp at 10:30 at the same time and signed the entry register with the same ink, with the same pen. And that was also considered to be a circumstantial piece of evidence. So, I mean, the rule is that merely price parallelism is not enough to implicate you, but you need circumstantial evidence, something called the plus factors, to be able to pin you down. And all these things actually add up and kind of can help the DG basically prove that this price parallelism was not merely a coincidence, but it was a well-planned agreement which has kind of taken this form. And other instances, I think, are financial dealings, etc. But I'm not going to waste more time on bid rigging. But my suggestion is that yes, there is temptation, but please be very, very careful that, and these have been some traditional ways, because when you're dealing with the government, the mindset is slightly different. There is a public tender, and there are a lot of other extraneous considerations, not just competition. And I've come across multiple considerations which play out, but ultimately most of the cases do end up before the commission, and this is a high risk proposition for MSME. So my suggestion is, please be very careful in how you bid, in terms of positive documentation which you maintain, in terms of arriving at the price which you will put as the final bid price, etc. Now, moving on to trade associations, I have Sohail, if I could request you to move to trade association, which is slide number 6. I'm sorry, I'm just going a little all over in the interest of time and not strictly following my slide deck. But there's a very, very interesting quote from Adam Smith from The Wealth of Nations. And he said that people of the same trade seldom meet together, even for merriment and diversion, but the conversation ends in a conspiracy against the public, or in some contrivance to raise prices. I couldn't hear what you said. I'm sorry, there is so much technology all around that, someone is always listening to you. And Mr. Kumar did touch upon privacy and data issues, but that is one of my voice assistants listening to what I've been saying. And unfortunately, he is not able to follow what I'm saying, but some of the audience hopefully is able to follow what I'm saying. But I think the key point about trade associations, and trade associations have been the norm in most of the many industries in India. But based on what Adam Smith said, I think that's kind of reflects the general perception of competition authorities across the globe. Because most competition authorities frown upon the fact that competitors are going to come together and discuss certain things. It may be legitimate things, and when they are sitting together, it's kind of certain there'll be some discussion on the side over tea, which could involve some sort of strategic or commercially sensitive information, and all these discussions reduce transparency in the market. So whenever you are dealing with trade associations, just be extra careful, because the moment this issue of trade association goes before the commission, the first reaction is going to be a frown. And I am not saying that trade associations are not a good way and there are no legitimate industries issue or government representations for which trade associations actually do help a lot and are a good platform. But one has to be very, very careful, especially in the last decade or so of CCI's enforcement. There have been multiple cases over and over again, whether it's film industry, whether it's pharmaceuticals, the cases keep coming up. Another point on the legitimate purposes of trade association is that sometimes, for example, if you are trying to get an anti-dumping duty imposed on imports from a particular country, you have to collect some data from various players to be able to show the injury which imports could have on the domestic industry. And that legitimately requires collection of some data from certain players. But even if you're collecting some sensitive data for a legitimate purpose, it is very, very important to have a firewall between the association and the members of the associations who are indeed competitors in the industry while handling sensitive data. And some of the industries have been wise enough to appoint a third party, completely independent agency which collects all the data from various players and then consolidates it and then disseminates that data. So be very careful, even if the purpose for which you are using the association is legitimate. Avoid any exchange of commercially sensitive information, any strategic decision which can reduce uncertainty. Now, like I said, aggregated historic data is generally all right, but whenever you are talking about contemporary data, when you're talking about pricing, discounts, any sensitive data, that is a complete no-no. Please do not discuss these in association meetings, either formally or informally. And if the CCI finds a violation, the penalty can be imposed both on the association and the office bearers, who are the individuals. And you would be surprised to see that, in more than one cases, the penalty which has been imposed on individuals has been higher than what has been imposed on the association, because association technically is not an enterprise which has turnover directly from sale of goods or services. But I think that position has already been clear that it's actually a collection of enterprises which come together, and association does have some form of income, whether it's membership fee or interest and all of that. And CCI does impose penalty on the association. But office bearers individually would also be liable for a penalty, and they will be fined. And that applies not just for associations, but also for enterprises, that the penalty under the Competition Act is not merely on an enterprise, but can also be on an individual who is responsible or who has consented to the conduct which was considered to be anti-competitive by the CCI. Another important point about trade association is that public distancing is the key. So even if it's a unilateral disclosure of some sensitive information by one party, that can also kind of lead to some sort of violation from you, unless you decide to publicly distance yourself. Whenever a sensitive topic comes up which was not part of the pre-agreed agenda, please object to it. Even after the objection, if the association meeting continues and the topic continues to be discussed, please ensure that your objection is noted and you leave the meeting, and then ensure that your exit is also recorded. The best way is always insist on a pre-agreed agenda, stick to the agenda during the meeting, and have a very clear note on the minutes of meetings. Everything should be recorded to avoid any confusion. There are multiple associations now, given the high number of cases before the commission dealing with trade associations. They also have a competition lawyer who attend the meeting, who can actually, as an expert, indicate and object to any issue which is being discussed, which may raise the risk of competition violation. So, short point, trade associations, yes, we all understand that it is very difficult for you not to function without a trade association, but just be very, very careful and ensure that you are using it only for legitimate purposes. I've been getting calls from PhD. Clearly, I'm kind of running over my time. And very quickly, let me please mention about resale price maintenance. I know this issue only pops up when you are offering any popular good or services, and if your market share is generally below 20 to 25%, you don't have to bother about this. But it does happen because markets are defined in a specific way. One product may be a market, 10 products can be part of the same market. So you are not certain in terms of what your market share is going to be unless you know the precise definition of the relevant market. But if you think you are offering a popular goods or service, then please ensure that your dealer or distributor has complete freedom in terms of determining the resale prices. There have been multiple instances, automobile industry, certainly one which comes to mind when it comes to resale price maintenance, that cars cannot be sold below a certain price. And there are multiple ways of monitoring this. There are third-party mystery shopping agencies which are hired and which report the dealer prices to the company. So please give complete freedom. You may recommend a price, but that recommended price should not in any way become the final retail price or the minimum operating price. You can fix a maximum price, you can recommend a price, but please do not fix the minimum price, which includes don't fix the maximum discount or the margins of the dealer. There has to be a complete freedom to the dealer to decide the final retail price. And finally, coming to the compliance bit of it, that prevention is better than cure. Vivekji, I am aware I will not take more than 30 seconds, that I'm running short of time. So not a tick box approach. The message needs to come right from the top. Live the compliance culture. Don't let competition law come in your way. There is way too many resources which are expended on managing investigations by the CCI, complying with various orders, exposing yourself to compliance requirements, then also penalties, cease and desist, and in case of non-compliance, maybe some criminal sanctions which can appear at some point of time. So please follow all the standard do's and don'ts, and try and avoid any downgrade or any adverse situation which may arise. Have a standard compliance policy, have a one-pager, distribute it to all your employees, key employees, sales and marketing staff, so that they are educated. Most of the violations which I've seen in my practice is because people are just not aware that what they can do or what they cannot do, because they have been trained for decades to do business in a particular way. And unfortunately, they are not aware that, if they bump into a contemporary at a dealer counter, that they just can't discuss that they're going to increase the price in next 2 weeks, because they just want to know what's happening. They want to tell what's happening. And, these discussions inadvertently lead to some sort of competition violation. So please seek legal advice and try and stay on the right side of the law. Thank you so much.
Thank you very much, Vivekji, for indeed a very, very interesting presentation. And I think it dealt with almost all the aspects with a complete 360-degree approach. Truly very, very informative. Thanks a ton. I wish we had a little more time to delve deeper into each of your slides. With that,
Vivek
I'd like
ji,
to request. Yeah.
One small thing. For all the panelists, I know you're a learned person. Whatever you presentation which you have, and because we don't want to be unfair to Mr. M. Sharma or to Aditi ji, because if we have, without any, if we have exceeded the time, I will request all the panelists, whatever they wanted to say, if they can just give it to us, send it by email, and we will make sure that we will share it with all the 110 participants who are today, plus apart from that, with all our members. So that will be a big help to everyone. Thank you.
Sure enough, Senior VP, we'll do as advised by you, and we will seek the presentations from the speakers. May I now request Mr. M. Sharma to kindly give his presentation. Mr. M. Sharma is the head for the Competition Law and Policy Practice at the Vyas Associates Advocates. Over to you, Mr. Sharma.
Thank you, Mr. Saigal, and I must thank particularly the chairman of this Corporate Affairs Committee to include me as a last-minute inclusion as a speaker. And I was listening with amusement what my predecessor just mentioned about the Gurdwara mein bhajan chal rahe the. Unfortunately, that was a matter, the first leniency filed at that time, and we were trying to defend that unfortunate person. Anyway, my subject is totally different. So I am going to discuss briefly on big data, how it interfaces with the competition law, the data privacy issue and competition law. It is a very contentious issue, and I don't have a presentation, so I will be just speaking from my notes, and I request everybody to kindly attend because the subject is slightly a very specialized area which is still being debated all over the globe. So big data are generally known as the oil of the digital economy, as Mr. Dhanendra Kumar also rightly said, and particularly the personal information and the personal data which we are made to agree to share with the large social platforms like WhatsApp and Facebook, etc. They do raise competition issues. But whether the Competition Commission of India is equipped to handle these issues, because these issues are very, very sensitive issues and very, very specialized interaction of economic issues. Traditionally, privacy and data protection concerns such as are regarded matters outside the scope of competition law, because in mature jurisdictions, there are special laws for handling private data, such as we have GDPR in the European Union. But the issue is whether the use of personal data, say by this platform like WhatsApp or its parent company, for commercial purposes, is it unfair? I ask myself a question. Do end consumers have any problem with this? Because the use of this data leads into advertisement, targeted advertisement you get, which actually seems to widen the choice for selection. So where is the competition issue? Traditionally, consumer welfare is considered as the ultimate objective of competition law all over the world. So the aim of the competition law is to have consumer welfare. It should welfare the consumer. But this aspect is taken care because this results in competition because it lowers prices, as Mr. Dhanendra Kumar already said, improves quality, etc. But the issue is now why the issue is being debated globally. I would like to discuss this very, very specialized competition issue. Why this data privacies have become an issue at all? Has the consumer welfare aspect of objective of competition law lost its relevance? And now, because of the unique business strategy of these large digital platforms, so what is the business strategy? See, the markets are becoming digitalized. As we said, digital economy, you can call it, new age economy, you can call it. The markets are becoming digitalized. And data, as is known as the oil of the digital economy. So how it is that these platforms, or how it is this digital player, so-called, what is their strategy? So I'm going to very, very quickly tell you what the strategy is. So the unique features of the digital market, I'm going to deal with in little detail, is there are 4 or 5 unique features which we must know. The network effects, direct and indirect. So network means that the bidder on one side and the consumer on the other side. So both sides benefit. The data is a critical input. And then there is use of advanced analytics, the algorithms. And there is asymmetry information altogether. So you do not know who's the bidder, who's heading the highest bid. You don't know who's coming on the top of the search. All those issues are there. So what are the main issues? The main issues which have been highlighted over and over again is, and there are 4 or 5 issues which I'd like to highlight. The first issue is market power and self-referencing. So we have the Google search engine case, we have the Amazon cases, the self-preferencing given to the related entities. So these digital resellers have their own preferred sellers. So they will come surge in ranking. So if Amazon, I'm just giving an example. I just suppose Amazon has its own related entity which it has a stake of 25%, suppose. Then if you search a particular product and the product is being sold by the preferred seller, that seller will come on the top of the search engine of Amazon. And apart from that, they will also give deep discounts. It's not only that the preferencing given the search ranking, the discounts are also given to those preferred sellers. So self-preferencing is one of the issues. Then the second issue is market power and exploitation. That means the use of the personal data by these players, how it is exploiting the consumer, because the consumer doesn't know that his data is being commoditized, is being commercially used. So in fact, this matter went to there is an example in Germany where the Facebook was fined, but the German appellate court actually stayed that order. They say violation of privacy rules is violation of competition law only when you can show an harm. Where is the harm? So the harm is this. This harm is a new theory of harm which is now emerging. The theory of harm is self-preferencing and killing competition by having potential competitors. So Mr. Kumar mentioned that how the platforms are taking over new entrants. So Samir Bhatia, Hotmail was consumed by Microsoft long back. So every new competitor which emerges is taken up. For example, WhatsApp was bought by Facebook at that time for 1 billion, for 19 billion, though it was very only 1 billion, as Mr. Kumar rightly mentioned. Why? Because they could see the potential. So potential competition is being killed. So that the question which has now started coming to the people point is that the consumer welfare model, which actually rules both sides of the Atlantic, whether the US or the EU, is still valid or not. And the debates are being done across that. I would request all of you to kindly see a movie on Netflix to understand in totality the social dilemma. I don't know how many of you would have seen this movie. I will request everybody to note this name, the social dilemma, where the ex-employees of these big giants have come forward and explained how their data is being used. So they got one person, they got 3 algorithms. The moment you like a particular product, next time you will see only the same product, the advertisement will be given. For example, my wife likes bhajans, so every time she'll have bhajans only on the YouTube. So this is the way they have got one person, they got 3 algorithms to monitor that one person. So everybody of us is being watched by Google, and so we have to be very careful that how this data is being used. So the point is that these are issues which have emerged, and how this actually affect the competition. There is a very interesting debate on this. So the digital platforms are having their own ecosystems. So ecosystem is controlling ecosystem. There's a private competition. And how do they emerge this? So there's a private competition within the platform. So what is the strategy they use? The lever 1 is hook the person. Lever 2 is extract its personal data. And lever 3 is use that data to attract bidders. So that's how the network effect works. So if you have more bidders, if you have more data with you, the more bidders will come. So it's both sides. And then you data harvest. After the data, they do data harvesting through use of algorithms, and even not only by themselves but also by the third party, they sell it to it. And there is a behavioral discrimination. So the point is that the personalized pricing is given to everybody. Amazon, for example, has millions of dynamic pricing, millions of examples for pricing different changes. So these are very, very highly economic issues, but the good part is that even in India, these issues have emerged. And I'll very quickly touch about the examples which have happened in India. So the Google was the first case in 2018. CCI penalized it for abuse of dominance in the market for online general search and web advertising services on the complaint by Bharat Matrimony. I think some of us would remember that case. And it is again being investigated for its alleged abuse of dominant position by restricting conditions for use of Android operating software for smartphone. This order is of 2019. And another investigation has started against Google for leveraging its dominant position in market for licensable mobile Android operating software and for the market for app stores for Android operating software to protect its market position in the market for apps facilitating payment through UPIs. So you must be aware of Google Pay. So what is happening is that, and some of them came to me also, what is happening is that the third-party apps which are on the Android software, Android operating software, which are used by most of the phones except the iPhone, if you have any purchase made through those apps, so Google mandates you to pay through Google Pay, and it also charges 30% commission. So this issue has also gone to CCI, and the CCI investigated. So these are very, very highly, these platforms are, some of these platforms have, revenues more than the economies of the third world countries. So we understand what are we dealing with. So the invisible hand, I use this phrase very frequently because this was used by Truman, now by the United States. The invisible hand of the market forces is now being changed by the digitalized hand. So the digitalized hand is actually controlling the market, and there are digital comparison, comparison tools. You got your Google, hey Google, play this, or the Amazon's player, and there are digital butlers coming up. And so there is a possibility of digitalized collusion also. So I'm just trying to highlight these issues that, as I said, if you see Social Dilemma, you will see this. So apart from Google, the Amazon also, the large one of the next large is the Amazon, is also facing the possibility of investigation by an order of CCI of 2020, January 2020, for more or less the same issue: preferential treatment, surge in ranking, deep discount. But there is a stay in their favor by the Karnataka High Court, and maybe there is some leak which I cannot discuss as of now by the media in the US, which may put their situation at a disadvantage. So now I will focus straight away on the data privacy and how it interferes with the competition law and how it is slowly evolving in India. Let us see the case of WhatsApp. So WhatsApp, the first case against WhatsApp was filed in 2017 by an NGO, which said exactly the same thing, that WhatsApp is making the user share its personal data, and it is also sharing the data with Facebook, its parent company, which is also sharing with third-party apps. Now, CCI examined in 2017. Till 2017, let me remind friends that CCI was giving a soft glove treatment to these e-commerce players because the market was emerging. They were very light touch was being given. So they were not very interfering into these markets because they thought this is an alternative mode of distribution of services and the market is evolving. So in 2017, the CCI examined this case, but it found that the manner of this, and the allegation also said the manner of the so-called consent by the user is highly deceptive and it constitutes abuse of dominance. And the allegation was that not only it abuses of dominance position of WhatsApp, but it also violates the Information Technology Act 2000, because you take the consent of the person without its written permission, or without its permission there is no 65B etc. used. So CCI considered this complaint and determined the relevant market. Interestingly for all of us, that market for instant messaging services using consumer communication apps through smartphone. And in this so-called defined market, the Competition Commission of India found that the WhatsApp was dominant. But it closed the case. Why? Because it found that at that time in August 2016, policy of WhatsApp allowed the consumer, allowed the user of WhatsApp an option to opt out for the option of allowing the WhatsApp to share its data with Facebook within 30 days of giving consent. So the 30 days period was there at that time. That means within 30 days, if you have opted to share your data with WhatsApp, you can still say, I do not opt for sharing my data with Facebook. That policy was there. So the CCI said, well, on this reason, we closed this case. Of course, the other reason was CCI found that it is not a competition issue per se, because CCI felt at that time that it is an issue which is of privacy. The right to privacy in India is a fundamental right after a celebrated judgment of the Supreme Court in 2012. And the Supreme Court, the PI, was already there. So CCI closed at that case at that time. The second case against what Facebook arose in 2020 very recently, but that was for digital payment. And because WhatsApp had started, if you remember, the digital payment through WhatsApp, the CCI closed that case by saying that it's actually a premature complaint because they've just launched this new payment model. So the root issue now
Mr. Sharma, sorry for the interruption, but I'd appreciate in case you can concise it a little further. Thank you.
I would. I have only 5 minutes. I'll take, not more than that, because I'm sure that you'll be fair enough to give me some time to explain an issue which is very controversial, and there are Supreme Court also intervening this. So the moot issue is that WhatsApp's new data privacy policy, which is they have launched now in January 2021, how it affects the competition. So what are the main issues in this policy? As I said, that unlike the 2016 policy of the WhatsApp, the present policy proposes that the user will have no choice now. So you don't have a choice to opt out, which you had earlier in 2016 policy. So after 2020 and the 2021 policy, every user of WhatsApp will have to per force allow WhatsApp to share its data with Facebook, and that data can be shared with any third party, apps, etc. So Indian users are, that means the Indian users, because we don't have a data privacy law in India. We do not have a data privacy law. The bill is still in the parliament. There's a JPC constituted. So how do we save ourselves? Because before, and this interestingly, a PIL was also filed in the Supreme Court on the same issue. You may have read in the newspaper in the Supreme Court. So the central government opposed WhatsApp, and they sent a number of questions. But what the counsel for WhatsApp said, And Facebook said that there's no law here in India, and you expect us to follow a law which doesn't exist. How can you do that? I don't know how the Supreme Court will deal with it because of the right of privacy, etc. But to that extent, perhaps the WhatsApp position is right, because unlike GDPR in European Union, the law is not there. So there's a vacuum. So the government of India, through its legislative response, is trying to bring out this new personal data protection bill, which is before the Joint Parliamentary Committee. I'm trying to touch base with the honorable members of the Joint Parliamentary Committee. I've already spoken to Msme on this. And so this Data Protection Authority, etc., which is showing, but unfortunately that bill has no interface with competition law. It doesn't deal with this aspect, which I'm going to try and explain to you. So the point is, what is the answer? To me, the answer, my hypothesis is this, that to me the answer lies in using the competition law effectively, which I urge upon the Honorable Competition Commission, and we have an Honorable Representative, Mr. Dr. Sanjay Pandey, here with us, and I'm sure that he's listening to me. So the point is that how can the CCI handle this data privacy issue? Can it do it in the way the Germans, the Bundesrat in Germany has held? It cannot, because the law is specifically provided. We don't have such a law. But according to me, the solution is the use of the provision of abuse of dominance. Now, WhatsApp, incidentally, has the largest market in India. The number of users of WhatsApp is exceeding 340 million in India, and WhatsApp is being downloaded on 96% of the devices, and as 97% of the users use WhatsApp in India. These are all statistics which I'm using. So either you define the market as social media platform use in India, even then WhatsApp is having more than 70% market share only after YouTube and Facebook, or if you define the market narrowly, which normally is done by the large platforms that market for message exchange apps on smartphone, even then the WhatsApp comes on the top, followed by Facebook and Truecaller, etc. And Facebook Messenger comes as the fourth. So I think, in my view, the dominant position of WhatsApp is undoubted. And since in the 2017 case, which I just mentioned to you, the Competition Commission of India has already held that in this messaging market, on using smartphone, WhatsApp is dominant, so there should not be a problem in holding WhatsApp dominant. And now the question is whether it will create abuse or not, because at that time the Commission closed that case, because the case was still on. Now, even now the case is on in Supreme Court. But my hypothesis is that what is happening is that this big data which WhatsApp is using is actually creating entry barriers. It is destroying the level playing field for its competitors like Hike, Telegram, and other services which are there, which are trying to come up in India as well. But because of this big data which WhatsApp or Facebook have, they are not allowing, they cannot match. So the level playing field is actually destroyed. The market equilibrium does not exist. It is tilting in favor of, heavily in favor of these large platforms like WhatsApp. And as they say in competition law, it is the competition for the market. There's no competition in the market, and the market is already tipped in favor of these people. And luckily, now I see a change in the Competition Commission's thinking. And there is a recent study which they have released on telecom sector, and in February 2021, and the Competition Commission has recognized, and I'm quoting that, data privacy can take the form of non-price competition, and abuse of dominance can lower privacy protection, and that an aspect of data is in the context of competition in digital communication market in conflict with allowing access and protecting consumer privacy. So unquote. So the healthy signal is that Competition Commission has now started looking at data as a non-price competition parameter. Most of the cases which my learned friend, my predecessor, Mr. Agarwal mentioned, are all related to prices, whether it is bid rigging, abuse of dominance, all they are price-related competition. So there's another parameter of competition which is quality-related. There are 3-4 parameters on which the competition takes place. So this data actually, with the digital economy coming into fore, and all of us have, and the pandemic or no pandemic, we will continue using digital economy. So the data has now become a source for a very, very important source for measuring competition. And this I would like to, before I conclude, I know I've been getting reminders, I'll just make 2 quick points. That how the Competition Law Review Committee, or the bill is in the Parliament, has handled, has the CLRC looked at it? Well, they have looked at it, but they have looked at it from the point of view of mergers, because they're saying that that the deal size could be considered as a parameter for considering the competition between the platforms when they are merging. That aspect is still being debated, because they have not said categorically deal size, but the competition authority may consider suitable, so-called suitable parameters to look at the competition when they are considering these so-called big ticket mergers. But what is missing in the competition law review committee also, and not in the bill, is also in the bill, is the absence of cover the attempt to monopolize. Now, this is a thesis which I want to submit before this gathering, that there is no provision in the Indian Competition Act under Section 4 to curb attempt to monopolize. So if you will appreciate that all these big players, whether it is Amazon, whether it is Uber, whether it is Facebook and whatever, they're all, none of them except for WhatsApp, because I just said, can be held to be dominant clearly in their markets. But there are, so if there is Amazon, there is Flipkart. But both of them, if they are doing the same thing, deep discounting, surge in ranking to preferred sellers, then where do these small companies go? Where do the other traders who are trying to come on board, they just cannot match? So there should be, according to me, a provision in the new bill which should also prevent attempt to dominate the market by these methods. And I wrote a small piece on this, if I can request Sohail to show that screen share, that full piece. It came in the Economic Times, and I would request some of the, if you have time, please look at this. And this was precisely on this point, that the Competition Amendment Bill has not covered for attempt to monopolize. So with this, I think I should conclude, and I'm open to questions if any. This issue is highly debatable, and I'm sure that some of you might like to look at it from the perspective that I've given. Thank you very much.
Thank you, Mr. Sharma, for an indeed excellent talk this evening, and getting into the details of some very, very important aspects of the competition law. I have a tough task for Aditi, Ms. Aditi Gopalakrishnan. Thank you very much for your patience, and really appreciate it. So Ms. Aditi Gopalakrishnan is the partner in AZB and Partners, and would like to have a quick presentation on the competition law enforcement, the trends and the compliance aspect of it. So over to you, Aditi, and once again, thanking you for your patience.
Thank you, Mr. Saigal.
And we do like to save the best for the last.
That's very kind of you to say. And thanks very much to the PhD Chambers of Commerce for inviting me back. It was a pleasure to speak to you the last time around that I was here. A special thanks to Mr. Naveen Gupta, who I had the pleasure to interact with last time around. I think I want to reassure you, Mr. Saigal, I do see a lot of panel fatigue setting in, so I'm going to try and keep this as quick as possible. I'm actually going to, hopefully whiz through these slides that Sohail is kindly sharing. And what I now see my role as the fifth speaker here is to really recap what we've discussed so far. And this is also because a lot of what I was planning to cover has actually been discussed to a certain extent in previous presentations. So I think what I can do is to sort of zoom out and kind of look at, give you a sense of where we're at with the CCI in terms of the trends that we're seeing and where we sort of see this going. So with that background, I'll start the presentation itself. So we know that the Competition Act has three areas. The Indian Competition Act has three areas that it regulates, similar to other jurisdictions. It looks at agreements, it looks at anti-competitive agreements, it looks at prohibition on abuse of dominance.
We'll request you to come closer to the mic, please.
Sure. Are you able to hear me better now?
Yes, very much. Thank you.
Okay, no problem. Let me know. Do give me a shout whenever you can't hear me. So I think the three areas are, like I said, anti-competitive agreements, abuse of dominant position, and regulation of combinations. I've sort of left out regulation of combinations in kind of examining trends, because I think our the audience here and the panelists would likely be more interested in the first two areas. So I'm going to stick to that in this discussion. If we look at a very broad overview of what's happened over last year, I'm not limiting it just to 2020, but over 2019 and 20, is that we've seen that the Competition Amendment bill has actually been is being considered in Parliament currently. And I think the bill, as Dr. Pandey mentioned right at the beginning, has some pretty major changes that it proposes to introduce. Things like settlements and commitments, things like changing merger thresholds. These are all pretty major changes that are proposed in the new version of the Act. So I think that's something to look forward to in the coming months. Another important trend that we've seen is the market studies that the CCI is doing. Again, this has been covered in previous rounds of presentations. We've seen that the CCI has actually not limited itself to a certain sector. We've seen them kind of have a wide net and look at areas like pharmaceuticals, private equity, telecom and e-commerce. They've already concluded their market studies, and what this really tells us is that they're kind of they identify issues that are currently going on. Like, for instance, in private equity, they see there's a lot of discussions with private equity companies in terms of how to regulate them and how to kind of address issues of minority acquisition. With respect to pharmaceutical companies, there's issues of how does the discount structure really work? How does the retail setup really work? The distribution channel, how does that really work? And I think that this shows a certain sense of curiosity within the Commission to kind of understand the industry and then take action, which is of course very commendable, because I think any competition regulator can really work with can only work when they have the best information. So I think the CCI is on the right track in kind of doing all these market studies. Over the last year or so, what we've also seen is that the CCI has been very conscious of its role in the backdrop of the pandemic. So I think the easy answer would have been to take a slightly more aggressive role and say that horizontal agreements are going to be a problem no matter what. But I think they've applied a more sort of nuanced understanding of competitor collaborations, that not in all cases are competitor collaborations a bad thing. You can have there are certain collaborations which may not be problematic, and the Act itself recognizes that. I think there are inbuilt safeguards in the Act that exist to kind of protect those kind of collaborations. And I think it's important that the CCI sort of put out that advisory that it did on COVID-19 and kind of recognized that and made that clear to business, disseminated that information, that it didn't come in an order, but it came in on the CCI's website where it made its position very clear. What is also very encouraging is that it's sort of been like the CCI has not been closed for the past year or so. It's been working phenomenally, and it's been working exactly in the way that it was pre-pandemic. We've seen a lot of enforcement activity. We've seen a lot of decisions at a prima facie level, so a lot of cases moving into investigation, as well as the review of combinations, which is again an important part, because deal work doesn't stop, and you keep needing competition approval for transactions that meet the asset and turnover thresholds. And again, the CCI sort of made that easier by starting video conference facility for discussions with the CCI and for hearings. And what they also do is accept e-filings now. So that's a really broad 1,000 feet angle of what's happened over last year. If I can now take you through the first set of issues, which is really on horizontal agreements, what it means and what the trends that we see. I think I'm going to whiz through this slide because I think a lot of panelists have already talked about this. Horizontal agreements are really competitor collaborations or cartel activities, which are considered to be the most problematic type of anti-competitive activity and are presumed to cause appreciable adverse effect on competition. AAEC, which is the word that competition lawyers like to throw around, but that's really the test that runs throughout the Competition Act. So competitor collaborations are perceived very strictly under the Competition Act and are prohibited under the Competition Act, certain types of competitor collaborations. And if I can move to the next slide, Sohail. And the trends that we've seen over last year is that the CCI has been very active. What we've seen is that it's issued 11 decisions that involved detailed DG investigations. And in most of these, what we saw is that the CCI did not find that the level of evidence was actually shown, and it's actually dismissed those cases after a detailed investigation. We've also seen several cases where it did actually find a violation, but what we've seen is that there have been some cease and desist decisions. So it's been telling the parties not to do the conduct in the future, but no actual penalties. And these have been for various reasons, but one of the reasons, just taking from Vivek's presentation, was actually that they recognized, the difficult situation that MSMEs are in under COVID-19, and that was actually one of the mitigating factors that guided their decision into not imposing a penalty. And I think this is important because here the CCI is not acting, purely looking at the deterrence power that it has, but it's also kind of looking at the situation that's in and then kind of using that to kind of guide its penalty power. And that's really important that it did that, because and that's in line, in fact, with regulators outside India, where I know the OFT had some guidance that said, small companies and companies with low turnover should be treated differently, even if they cause an effect on the market. There should be some sort of consideration to whether you destroy a company as a result of the penalty, and that's something that's clearly resonated with the CCI as well. What we've seen is that, in terms of their review of horizontal collaborations, if you even review the, the decisions that they have at a prima facie level, and just to just to kind of give the audience here a sense of things, what you have in a CCI process is that, you bring a case to the CCI, the CCI looks at it, it says, prima facie there is a case, or prima facie I dismiss it, and then prima facie, if there is a case, then they'll order an investigation to the Director General. The Director General will do the investigation, submit its report. CCI will look at the report, send it to the parties, and then issue a decision. And that's the general process in the investigation. And what we've seen when we reviewed, the prima facie decisions, which is the initial complaint that comes to the CCI, is that the CCI has generally said in its decisions that it's important that a certain level of evidence is actually provided before, when you're alleging cartel conduct, and you can't waste agency resources with just pieces of paper that mean nothing. So I think, for people who are considering filing a complaint with the CCI, that's an important guiding principle that one needs to kind of bear in mind. Another sort of trend that we've seen is that, the CCI has conducted some dawn raids over last year. This was surprising to most people, because it was surprising to see that there were dawn raids and these strong investigation powers were used in COVID time. But the CCI had processes designed and planned for this, and they raided several cement companies and trying to uncover evidence of cartel conduct. For those of us who don't know what dawn raids are, these are surprise search and seizure operations. So it's called dawn raid, but it can happen any time of the day. And it's really the CCI coming in without warning into a company's office, asking for information, collecting evidence, interviewing employees, and that's the process that's generally followed. So those are the trends that we've seen in horizontal agreements. In the next slide, I've got some key decisions, but I'm actually not going to go through this in the interest of time. Just to give you a sense, though, that there have been dismissals, like what we've seen in the airline cartel case, where the CCI, after a detailed investigation, has said the top domestic airlines in the country have actually not colluded to fix passenger fares. And there's no evidence to suggest that, even though the software to kind of arrive at passenger fares might be the same, but actually there's no evidence of collusion between these airlines, because ultimately it's human intervention that played a role. In the bearings cartel case, the CCI did find a contravention, but did not ultimately impose a penalty. Similarly, the Federation of Booksellers case was actually, it's actually not similarly, it's a different type of case. Here you have airline cartels where it's a dismissal, bearings cartel where there's a contravention but no penalty, and the Federation of Booksellers case where there's a contravention and minimal penalty. Just moving on quickly to the next type of issue, which is really vertical agreements. And you'll recall we discussed this last time, which is vertical agreements are agreements between two levels in a supply chain. So between a manufacturer and a distributor, or a wholesaler and a retailer. Those are the kind of agreements that are covered under vertical agreements. And I think Vivek covered this in his slides as well, that there are various kinds of vertical agreements that are problematic, like resale price maintenance, refusal to deal, exclusive supply, and things like that. But I think the key point to remember is that for a vertical agreement, it's really effect on competition that matters. So it's not enough to say there is an exclusivity. That exclusivity has to actually lead to an actual effect on competition for it to be a competition law violation. So if we look at the general trends that we've seen in assessment of vertical agreements, we've seen that that the CCI has in fact said that it's not enough to bring a consumer complaint to the CCI and say that, hey, I have a problem because this supplier refused to deal, refused to supply me goods, and that's not enough. I think consumer complaints, the CCI has said, is outside its purview. There are laws for that. There's a consumer protection authority for that, and the CCI is really there to litigate and consider competition law complaints. They've also said that we talked about effect on competition earlier, and how do you look at effect on competition? And what the CCI says there is that, look, effect on competition is really connected to market power. So as a supplier, if I'm denying you access to certain goods or inputs, then the only way that that's actually going to cause an effect on competition is if I'm, as a supplier, have high market power in the production of that input. And if I don't, and if you have alternate supply channels, then there is going to be no likely impact on competition. So I think that's the lens that the CCI applies in its decisional practice. And loosely, the market share threshold that they consider is about 30%, but this is not under the Act. This is just from the decisions that we've seen. In the recent past, the trends that we've seen over the last year or so, again, this was covered in earlier presentations as well, is that the CCI has shown an interest in e-commerce platforms, and a lot of this has come from, it's not COVID specific, I would say, it's actually pre-COVID that this interest has actually emerged. The CCI did an e-commerce study. It also, on the heels of the e-commerce study, it also issued a prima facie decision ordering an investigation into Amazon and Flipkart, and the kind of issues that it was looking at is, deep discounts and preferential listing, which is, the deals that Amazon and Flipkart entered into with sellers on their platform to kind of to do exclusive launches of smartphones and things like that. So I think what we've seen in this decision is an interest in looking at these kind of arrangements and seeing whether they cause an actual effect on competition. Interestingly, there was another decision but another decision involving Amazon in the fashion retail sector, where the CCI at a prima facie level looked at a complaint filed by Lifestyle Equities in the online fashion retail segment and said there's no case here, and actually dismissed that case because they said that the complainant here actually referred to the earlier case, the Amazon and Flipkart investigation, and said there are similarities, but the CCI said actually the smartphones sector works differently from online fashion retail. The fashion products online market in India is far more diverse. So we don't think you've established a clear case of an anti-competitive vertical agreement, and they dismissed that case. Finally, on abuse of dominance, you'll recall from previous discussions that abuse of dominance, it's not the existence of dominance position, but it's really the abuse of that dominant position that's prohibited. A dominant position is always with reference to a relevant market. So you define the products that you're dominant in, as well as the geography that you're dominant in. And that geography doesn't necessarily need to be India. It could be more limited than India. It could be a region. So for instance, if you're looking at something like cement, they look at regional markets. There are several products where they look at regional markets, whereas I would imagine for something like online retail or fashion that we were talking about earlier, you probably have an India-wide market. So so dominant position is really always with respect to that market that one is looking at. And again, if you look at the trends that we've seen over last year, as Mr. Kumar mentioned, we've seen a lot of focus on the digital sector. The CCI has looked at several cases in the digital sector. And what is interesting is actually, for me, is that a lot of this is not CCI initiating cases on its own, but it's really cases that have been brought to the CCI. So I wonder whether we should say that this is CCI's interest in the digital sector, or CCI reviewing a lot of people bringing cases in the digital sector based on what they're seeing, and the CCI reviewing that and kind of issuing decisions. So I think it's a mixture of that. And the reason that I say that is really, the last point that I make in that slide. Sorry, I know we're looking at the wrong slide now. So if you can move to the next slide. Great, thank you. So what I say in the last bullet there is that what we've seen overall is that individuals can bring complaints to the CCI. So you have a lot of not competitors, not exactly consumers, or not people who represent consumers bringing a lot of complaints to the CCI against digital companies, and that's been a trend that we've seen over the last year or so. It's not really the CCI suo moto initiating a case, but a lot of complaints that have been brought. And I think that comes from the sort of expanded definition of, who can bring a complaint to the CCI. And the Supreme Court has clarified that, individual complainants do have the legal standing to bring these complaints, because really competition proceedings are in rem, which means they are for the market. So if you have individual complainants who are able to establish a case, and the CCI will absolutely look at that. And that's been clarified by the Supreme Court recently. And that really takes me to the second bullet here, which is, WhatsApp Pay, Gmeet, as well as the GPay investigation. The GPay investigation was a prima facie order where the CCI ordered an investigation into Google to look at the App Store's payment system of purchases, and to look whether there are any issues there. And both WhatsApp Pay and Gmeet were actually dismissals by the CCI at a prima facie stage, where the CCI just believed there wasn't enough evidence to kind of proceed against WhatsApp Pay or Gmeet for somewhat similar reasons. And I think, again, the similarity that we see in WhatsApp Pay and Gmeet is that you had individual complainants who brought these cases. The CCI did a very thorough study of the market and looked at, how does an app interact with a smartphone, and how does it actually convert into usage, and what is the theory of harm there, and what is the sense of exclusion that other apps in the digital payments space might feel, and then kind of said that there just wasn't enough evidence to say that there is actually a competition issue, a tying and bundling competition issue with WhatsApp Pay and WhatsApp. And similarly with Gmeet, there was an integration that was challenged between Gmeet and the Gmail service, and the CCI said that there just wasn't enough evidence to show an abuse of dominant position. So this actually covers both anti-competitive agreements, horizontal and vertical, as well as abuse of dominant position. I'm going to leave you with just my sense of where we're at, which is that it seems that the CCI is a very prolific regulator. There's a lot of it's continued to work through the pandemic. It continues to work. There's a lot of engagement with other regulators. There's a lot of interest in kind of understanding what are the best practices and trying to incorporate that into its own practice. And the hope really will be that it continues to kind of look at evidence and look at evidence as seriously as it has, and kind of look at even at the level of prima facie investigation. And the reason that I call that out is that, at a prima facie stage, it's not a judicial stage. And it's where the CCI actually needs to look at whether there's enough evidence to order an investigation. So the hope really is that the CCI continues to kind of look at that requisite level of evidence before ordering the investigation. And that's what, we want to see more of, and we want to kind of hope that the CCI continues to do in the future. I'll stop there. I hope I've been quick, and thank you very much for inviting me.
So thank you, Aditi ji. I think very interesting discussion as what we had even at an earlier occasion with you. I think considering the time, I think you've done a great job to make things very, very clear. And I think we should not be, without taking any time, I'd like to request Mr. Aseem Chawla, co-chair of the Corporate Affairs Committee, to kindly sum up the excellent session which we had today with divergent views and the whole lot of knowledge which we could put together in this webinar. Over to you, Aseem ji.
Thank you, Mr. Sehgal. First of all, my compliments to yourselves and to the entire Secretariat, Ms. Gupta, in ensuring that you keep us honest on our toes, which is me here, Rustagi Saab and Honorable Ranka ma'am. We've had, I think the day really belongs, and how this new field of law has proliferated over time, and since afternoon, patient participation of over 65 odd delegates, which is a tribute to the excellent discourse presented by all the participants today. We are grateful to all of them. I mean, as an accountant, I can only say that the convergence of law and economics brings the best out, and it is all in the interest of well-being. I mean, even if you read the works of famous economists who end up dabbling on the legal side, and how they distill the best, as they say, for humanity. Very impressive deliberations. My compliments to all of you, and especially the 360-degree view presented in terms of whether you look at various forms. And of course, in absentia, I must congratulate the entire establishment of the regulator for continuing the uninterrupted job during the COVID period. I just hope that we will continue to have support of all the worthy speakers here. I mean, we've had in terms of veterans of Sharma Saab being present. I like your new look, Sharma ji. Yeah. And, yeah.
This is thanks to the COVID. It happened during COVID. I had a COVID, so I grew it up.
Yeah, and great work which we've seen today. Vivek, Aditi ji, and of course Honorable Mr. Kumar and Mr. Pandey. I think all in all, and Sharma ji brings his gravitas into the entire thing. Rustagi Saab, Ranjana ma'am, I mean, we look forward to some 2 or 3 more programs, as Suhail keeps on telling me. But we should take this assurance from all the meritorious speakers here that the Secretariat, if it does take recourse, we should have the benefit of their insight. So with this, over to you, Ranjana. And once again, thank you for making 3rd of March count Great job, all of you. Ranjana ma'am, over to you.
I'm up mute पे हैं.
Sorry. So let me again thank each one of you and the PhD, Corporate Affairs Committee members, Mr. Rastogi, Asim ji, and of course Vivek and Sohail, our sponsors, Baroda, and the other sponsors. Definitely, I'd like to thank Pradeep Multani for giving us this platform, for making this possible, these deliberations. I think they are so useful. And Aditi, I had occasion to hear part of your presentation because I joined late. I was traveling, so I just logged on. And but I'm sure the other speakers, where I can see Vivek and Sharma ji, I know that data privacy and digital economy are topical issues. Aditi, you raised so much of, given us an insight. It was almost like a master class about judgments and trends in competition. And Sharma ji, I'm sure you brought out a lot issues on data privacy. So with that, Vivek, thank you. And Anand Mishra ji, we are not able, we couldn't hear your inputs, but thank you for joining us in this deliberation. With that, I think Vivek, I hand it over to Vivek. Thank you, Vivek, for exceeding our expectations. We've had a great...
Yeah, and in fact, our chair keeps us equally keeps us honest. But today's exposition was absolutely par excellence, and looking at topics like corporate governance and role of auditors. So I mean, just airing or sharing the views with all the participants that still we'll try and keep up the momentum, and more importantly, value your time.
I want to add that we also want to bring out a survey on ESG going forward. So we'll reach out to all of you to join us in those deliberations and give your feedback. So thank you.
And thank you for holding the fort today.
I thank everybody. I also thank Mr. Sehgal for inviting me, and this was a very useful discussion. And I would only suggest, being a competition, being my focus, that please do consider having one more at least program on competition law in the next coming year. It should not come in because its a topic is markets and market affects everything.
Definitely, Mr. Sharma, and thank you, Madam Ranjana, for that wonderful vote of thanks. I think nobody could have done it better. And thanks a ton for your commitment to be able to join the webinar, even though for a vote of thanks. We have this recorded. Yes, we have this recorded, and we will definitely share the recording with you, so that as Asimji said, you can go through the masterclass and the extremely great deliberations which we had. We had some excellent points raised by Mr. Rastogi at the start of the session, after the chair and the senior vice president's address. So I think it's been a fantastic evening, great learning. And I'm sure all of us are feeling like sponges at the end of the day. Thank you, Vivekji. Thank you, Aditi. And thank you, Mr. Sharma, once again, for being here this evening and delighting us with the knowledge. Have a safe evening ahead. And my special thanks to Ms. Sohail Gupta. Sohail, give us a nice smile because you've done a wonderful job once again. And let us all clap for her to make this webinar a great success.
Thank
you, everyone.
That's hard, I have to say.
Right. Thank you, one and all. Thank you.
Right.
Thank you so much. Bye.
Thank you, Aditi. Thank you, Vivek.
And one day there was no questions, Mr. Sehgal. What happened to the questions? No questions?
No, there are questions, but if we get into it, then we will be having dinner over the webinar.
And
I'll share my presentation with you. I'll share my write-up to you. And you
Sharma, in any case, we are looking for more from you. So save the best for last.
Sure, I'm always there. Chawla, so nice to see you always.
Yeah.
I've been hearing you. I am so impressed. Thank you very much.
Thank you, Rustagi sir.
Thank you. Thank you.
Bye, Asim.
Sir, thank you.
Rastogi ji. Bye bye. Sharma ji.
Thank you, ma'am. Thank you very much.
Thank you. Thank you.